All right. Well, thank you to both Gerard and Earl. And we have four people that I have seen so far. Don't hesitate to catch my eye again. And I, um, yeah, and Gerard will now have a chance to reply.
Sure, thanks. I think I mostly agree with what Earl said. I mean, first of all, it is certainly true that Bingham was not a proponent of the broadest view of congressional enforcement power that you see sometimes discussed, well, for example, in briefs to the Supreme Court regarding things like Section 5 of the 14th Amendment or Section 2 of the 15th and so on. I mean, his speech arguing that the Civil Rights Act of 1866 was unconstitutional, implicitly, or they never expressly explained this, held that Section 2 of the 13th Amendment could not justify that kind of regulation, that you had to have a 14th Amendment in order to pass such a law. And furthermore, while it's fair to say Bingham took a broader view of the enforcement power in some respects than current doctrine would affirm, I do think that he was not sort of in that camp. So, I mean, in that sense, I agree. I also agree that he was certainly less enamored of Corfield than many other of his colleagues. And in this sense, one might say that he was an outlier. He only discussed Corfield once in all of his years in Congress, and that was in 1871. And they did it to sort of more or less say, don't pay any attention to it, or it wasn't something that I was particularly interested in, which, of course, was not the view of many members, including Howard, but also plenty of others. So the rejection of the first draft certainly was based on a number of factors. In effect, one reason for putting Corfield in at that point, I guess, is that that's the first point where it really comes up to some extent in the story. So I agree with those points, and, well, maybe I should stop and go with the questions then.
I did want to, since Earl was admirably brief and was still within his time, I was still waiting to hear the fourth point. Do you want to go ahead and finish? You had the the first three were that there was relatively no interest in Bingham after 1873, the Bingham versus Thaddeus Stevens, Bingham's role as the Lincoln prosecutor, and then you had us, maybe because I cut you off before you got to the fourth.
Right, well, the other thought I just would throw out there is, of course, Bingham's view was, as you know, that the Bill of Rights should apply to citizens against both federal and state action. Now, the question is then, what did that mean for aliens, right? And of course, you have the Due Process Clause and Equal Protection Clause that would apply to them as well. But interestingly, he did talk about the fact that free speech applied to persons and strangers. And so it is clear that at least in one respect, selective incorporation is correct, at least from his point of view, which is that, in fact, the Due Process Clause would protect freedom of speech as to all persons within the United States. Now, we can get in maybe later into the questions as to other particular views, but that's one thing that I had always thought that basically Bingham would be cited for being against selective incorporation, but the answer is, well, there was an aspect of it in which one could say that his views are consistent with that doctrine. So that was my fourth point.
Great. Okay. Interesting. And so the first group we had Chris Green, Tom Colby, and Bob Bennett. So.
Well, lots of fascinating stuff here. I guess three brief, detail-y sort of things. First, I wonder what you do with a couple of places where Bingham just contradicts himself like 2 months later. So in March 1866, he's criticizing, he says it's unconstitutional, but he also says the phrase civil rights or immunities includes voting, includes political rights when he's criticizing the first draft of the Civil Rights Act of 1866. Then in May, when the 14th Amendment itself comes up, he says, I got this language, but it doesn't apply to voting because Section 2 of the 14th Amendment makes that clear. And this seems like a really basic, important distinction, which, in March he says it's a bad distinction. In May, it sounds like he's making the distinction. And both times he treats it as if it's completely obvious. You have to be an idiot not to get it. And then in 1871, January 1871, he seems to say that the privileges in the Privileges and Immunities Clause is the same as Article 4 in his women's suffrage thing. And he quotes, I mean, he's got to be writing this in his own voice, I think, because he quotes Corfield, he quotes Story's commentaries, he quotes Webster's argument in the 1840 case. And then 2 months later, he says, well, isn't it perfectly plain that it's different privileges in his speech to the House in 1871? And he quotes the same three authorities. I'm tempted to look at that and just think, I just don't really care what John Bingham thought, because he really does seem pretty confused at a couple points. Second thought, so that's just one. What was I'm curious about his relationship with John Sherman, who shows up at several points in the story. Sherman gives a really interesting speech in February 1872, using the Ninth Amendment to construe the 14th Amendment. And the word chiefly in Bingham's 1871 speech, where he says it's chiefly defined in the first 8 amendments, you could construe that as a kind of Ninth Amendment-y sort of thing. Third thing, he is invoked as a framer in the 1871 debate. So Henry Wilson says, well, I agree with what Bingham thought. And Bingham, of course, wrote the thing. So there is this kind of originalist thing going on, at least in 1871. I think maybe Garfield saw, somebody else says something similar. I actually searched through the Congressional Globe. The name John Bingham doesn't show up after 1873, which is very, very odd. But it is in 1871.
And Tom Colby?
Yeah, great. Can't wait to read the whole book. I just want to pick up on, like Earl, I'm very fascinated with the Privileges and Immunities Clause and Bingham's, what he has to say about it. But what interests me is the way to tell the story that initially he thought there was a little bit of confusion among his colleagues about what the clause meant. And then he adds the words, of the United States. And then you seem to suggest that he thinks that that's taken care of it, that now it's cleared up. Now we know what that means. And I guess my question is, really? Did he really think that his second draft, the Privileges and Immunities Clause, was clear and that it would be obvious to a reader what exactly that meant? I mean, we live in a world now where we have a lot of originalists writing in the face of big data with a lot of access to information, and there's so many different originalist theories about what that clause meant, what it's about. Did he really think that he had written a clear piece of constitutional text, the meaning of which would be obvious to everyone going forward? If not, what was his game? If so, how could he be that naive? I mean, just 5 years later in Slaughterhouse, the Supreme Court divides 5-4 on what the clause means, and I don't think that any of the justices seem to think it means exactly what Bingham thought it meant. Were they being disingenuous? Which group of them? All of them? Or why does, I'm just curious, does he really think that this was clear language, and what would make him think that?
And Professor Bennett.
Yeah, well, I was actually just going to say something about, or offer a thought about why the 14th Amendment had been neglected in the sort of discussions of originalism. And I think at least part of the reason is that there is a sort of competing conception of constitutional interpretation, competing with originalism, that it's an ongoing process in which what happened yesterday has fully as much, if not more, influence on how we think about today than what happened the day before yesterday or many years before yesterday. That's what creates the problem of precedent and the tension in originalist thinking about precedent. How are we going to think about the ongoing process of interpretation? But there are other things as well. The failure to amend the Constitution is also affected by what happened yesterday. And constitutional amendments pose another more pressing version of this tension or dilemma as well. Some constitutional amendments deal with very narrow subjects, so when the 12th Amendment separates the election of president and vice president. It's sort of easy to deal with it. But the 14th Amendment, that's tough, and raises questions like, if the 14th Amendment understands privileges and immunities or due process in one way, does that affect the way an originalist should think about the same language in earlier parts of the Constitution? I'm not sure that this was a comment on your paper, and for that I apologize. But
As we get into the responses, I was just reminded to note that both the author and the commenter should feel free to respond, but don't have to respond to every comment, some of which are just stand on their own well. And that specifically that Earl as the commenter should feel free to jump in, and the people should feel free to direct questions to him as well. So go ahead.
Okay, so for Chris, so first, Bingham's relationship with Sherman, they didn't get along at all. One portion of some of my answers, I suppose, could fall into the category of I answer all those questions in the parts of the book I haven't given you. But in a part of the book I haven't given you, basically, Bingham wanted the Senate seat that Sherman got, and so they never really got along. The Ohio congressional delegation was quite a cantankerous group, with all sorts of rivalries during this period. Now, on Bingham's inconsistency, well, okay, so there's two explanations for that. One is sometimes he's speaking for himself, and sometimes he's speaking in some institutional role. So when he writes the report for the House Judiciary Committee as a judiciary chairman, he is speaking for the majority view of the committee, not for himself. So that leads to some inconsistencies. And when he speaks in the 39th Congress on behalf of or in support of a proposal of a committee, of a proposal of the Joint Committee on Reconstruction, he is also speaking as an advocate for them, or the majority view there, rather than for himself. So that accounts for some of that, okay? Some of it is attributable to the fact that he was a politician and he shifted his argument when necessary to get the votes that he wanted to get. And if that meant arguing one thing one day and something else the next day, he would do that. And, you know, what was his game? His game was to get the 14th Amendment written and ratified. And he was willing to take a number of extraordinary steps to get that done because he felt that that was the essential thing. Now, that's the thing where we could call into question whether he was on the right track. That is, perhaps others were correct in saying it wasn't, in fact, worth as much effort as went into it, that other measures, statutory measures or economic reforms or whatever, might have been a better way of resolving some of the problems that he had identified. But basically, those are at least, you know, a couple of potential answers. Now, on the clarity of the drafting, it's hard to answer that question. I mean, that is, Bingham never said very much about judicial interpretation of anything. And so it's hard to know what he thought about what people would think of the text or what was the best way to get the text through. I mean, I think that to some extent, some of it was simply a function of, again, getting the votes that one needed to get, and that was the formulation that was going to do that. Unfortunately, we don't know what he thought about Slaughterhouse. Because this is part of he never said anything about constitutional law after he left Congress. So there's really not a good answer to whether he thought they had betrayed his vision or whether he agreed with the holding but not the dicta or what. So he didn't really express a view that I think can clearly answer the question you're posing.
I have a couple of points specifically about the privileges and immunities language. And first, and Slaughterhouse. First, I would talk about that my version of originalism, and therefore the correct version of originalism, is slightly different than Randy's, in that, and everybody else's, I think, at this point, which is that it would be accepted legal meaning rather than accepted public meaning. And looked at from that regard, privileges or immunities actually it wasn't only Corfield. Corfield is only there's a whole line of cases which are basically consistent with privileges or immunity and the privileges and immunities clause of Article 4, except for this issue of voting. And I just want to put in a plug about Section 2 for originalists, by the way. And again, since I'm working on Section 2 right now, you should be aware that Section 2 creates a problem because under Section 2, the House of Representatives has been unconstitutionally apportioned since 1868. It was particularly unconstitutionally apportioned until the mid-1960s. And if you read the text, it's absolutely clear, and it would have made a big difference. But beyond that, so with respect to, it's an issue about originalism, constitutional interpretation, a whole lot of different stuff. But so that with respect to so I think that the answer is by putting in privilege and immunity of citizens of the United States, that was quite conscious. They clearly did make a distinction between privileges and immunities of citizens of the United States and privileges and immunities that existed by virtue of state citizenship, which gets back, we'll now get to Slaughterhouse, which is not necessarily the distinction that's been made. And it's very interesting because, once again, this is an interesting issue about originalist methodology. Because if you look at Miller's opinion basically is they couldn't have meant that. Whereas the dissenting opinion, which is actually more important than Field's dissenting opinion, is the dissenting opinion of Joseph Bradley, who basically said, this is what I describe as the super chicken rule. They knew the job was dangerous when they took it. Or, in fact, he said, I don't make them, I just read them. And if they wrote this badly, that's their problem. That because the privileges or immunities of American citizenship derived from Article 4 included a variety of, the argument in Miller is that it would give Congress the power to do what they said they didn't want to give Congress the power to do by rejecting the first draft of Bingham's first draft. Bradley's argument is, that's my problem, that's not my problem. Put that together with McCulloch, we hope it doesn't happen, but we're stuck with it. And so the answer is, I think, in fact, it is relatively clear, was by, except with this thing voting where Corfield is, in fact, an outlier. So that's as much of an answer as I can give. It's probably too much of an answer.
Okay, in the next group we had David Upham, then Donald Rips, then John McGinnis. So,
a couple of points here. One of the principal, seems to be kind of a principal thesis, is that Bingham undertakes a change that is as profound and as revolutionary as 1787. And the evidence you present indicates that at least he says he's not doing it. And I wonder to what extent you think he agrees with you that what he did is revolutionary. Because it seemed to me that he regularly said otherwise. And that's in sharp contrast with, say, the 1787. Madison in 40 and 43 and Washington identified as a revolutionary act. That the Constitution of 1787 was a revolution. It's a different posture from, I think, 1866. After all, they beat the revolutionaries. That's what their perspective was. This relates to a related point, and it's just one of my pet peeves. When people say that the first section of Section 1 overruled Dred Scott, it's my understanding they all thought they were just saying the law. They were fixing it. But they weren't. They were declaring the right law all along. And you provide the evidence for that Bingham himself had been saying this well before the 1866. That the Republicans thought that Dred Scott was just stupid and wrong. It was wrong when it was decided, and the right law was the common law rule that freedom and nativity give you citizenship. You mentioned on page 50, and I know you know this, but the way you describe Tawney's dissent from that position, it suggests it's an isolated opinion, that Tawney was the only one who didn't think that free blacks were citizens. I know you know that there's tons of cases that say otherwise, but I think the reader might get the impression that Tawney is a bizarre outlier in antebellum America in denying black citizenship. Here's an instance where, the third point is an instance where big data helps. You mentioned on page 65 and elsewhere that Bingham, when he said Bill of Rights, he meant Bill of Rights. And as you know, these statements in the 39th Congress have been parsed and parsed to death. And it's somewhat tiresome sometimes to try to argue exactly what did he mean. Was he talking about due process and privileges and immunities, or was he referring to the first 8 amendments? I just wanted to point out, you can type in Immortal Bill of Rights now in Google Books in the 1860s. and you find Virginia Declaration of Rights is called the Mortal Bill of Rights. Declaration of Independence is called the Mortal Bill of Rights. So it's hard to know what that had a precise term meaning, and it may very well be my own opinion is he actually thought the Due Process and Privileges and Immunities Clause together were special parts of the Constitution, and they were, in some sense, a Bill of Rights for America. And lastly, this is a point it's related to what others were saying about why the change, why privileges and immunities to privileges or immunities of citizens of the United States. And I mention this for the benefit of your work and also just in case I drop dead before I have a chance to write this article. The term, as you noted, Bingham notes that the word civil rights can be broad enough to include political rights. And as Earl pointed out, Corfield, if that's your authority, it's got this last little phrase about political rights, which could conceivably mean that if you keep the original Section 1 language, that you're going to give Congress the power to involve itself in political rights, involve itself in voting rights. I think one of the reasons for choosing of citizens of the United States is that it is incorporation of a gloss on the Privileges and Immunities Clause that says the only rights you get are not the rights that belong to the state's citizenship, including political rights. The reason you put of the United States on Article 4 is to clarify that it doesn't mean all of the privileges of membership, including the rights of citizenship, but it's designed to address precisely the problem Bingham knows, that words like civil rights and privileges of immunities of citizens might mean the right to vote and the right to hold office. I can talk more about that in other contexts, but I think that's probably the most important reason and why he thought it was clear afterwards. Sorry.
And then we have Don Drips, and then John, yes.
Yeah, I just wanted to start with your dog in the nighttime observation that he just has nothing to say about the 14th Amendment after he retires. And there's an extensive slaughterhouse contrarian historiography, and it shows up in some of the litigation in the Supreme Court as well. And I just find it very curious that there's no connection. So Flack, Guthrie, Paschal, those folks are pushing incorporation in the literature. The mainstream is otherwise. It's Cooley and Taylor and those folks. But Tucker makes an argument in the anarchist case and whatever that is, and then subsequently counsel in Maxwell against Dow. And if I were churlish enough to consult big data and power up my phone, I could give you the date and find out the lawyer on Maxwell. But I think it's about 1890. We met what we said in Hurtado, and we're not impressed by the speeches of Bingham and Howard. Those are just the national legislature, and here the real legislature are the people ratifying the amendment. Tom Colby will tell us more about the people and their august representality on that front. But if there is nothing there, there is nothing there. But it just seems to me odd that those folks are not in communication with each other and would not invoke Bingham himself and consult with him. That just strikes me as odd.
John?
What struck me was that, and this may be characteristic of abolitionist legal reasoning, is that at times Bingham makes what I think to an original seems wild arguments. The elision, putting in the United States in privilege and immunity. He has a due process argument that seems fully to me as off as Tawney's argument in Dred Scott. And this raises interesting questions, and I do think it's a live issue in originalism. Is the legal background of accepted legal methods for the 14th Amendment the same as it was at the time of the framing? It may be that because of the strong divisions in the country, that much wilder arguments become accepted as possible as part of the legal space of arguments. And what does that mean? Does that have some implications for how we should interpret the text of the 14th Amendment? In other words, that it's not against the background of the same kind of legal methods, or does that not true? Or is that actually, in some sense, is that a rejection of those methods because we actually ultimately put in the 14th Amendment because we don't accept? It wasn't so generally accepted that you needed the 14th Amendment to do what Bingham at times seems to think actually the original Constitution did, give a kind of privileges and immunities.
Okay, I'll take these a bit out of order. So I'll start with Don's question about what happened after 1873, or why did Bingham disappear? Okay, one explanation is he was appointed ambassador to Japan after he was defeated in his attempt to win another term in Congress. And so he was not here, basically, for the next 12 years. He was in Japan pretty much the entire time from 1873 until 1885. That accounts to some extent for why he made no public statements about cases. He was an ambassador, and that might have been considered inappropriate, or he might not have been following things quite as closely. It doesn't explain quite as much about the private view. I mean, to some extent, though, I think this may be a question more of what sources survive than what was actually going on. And after that, he was retired, and towards the end of his life, he had trouble remembering things. And so I think that also plays a role. I mean, the irony is that Maxwell v. Dow, which, as you said, basically rejects incorporation under the Privileges and Immunities Clause and then says, more or less, we're not that interested, or we don't give credit to the speeches made in Congress, comes out 2 weeks before Bingham dies. So that was sort of the last kick in the head, you might say, before his death. So I think it's partly a question of just, Bingham died broke, so his papers, more or less, were not kept in good order. And that may account to some extent for why we just don't have certain things that might have shed light on some of his views after he retired. Okay, now back to the first set of questions. There were a couple there from you, Dave. Okay, so the first is that, was he a revolutionary, or did he think he was a revolutionary, right? Now, he certainly did couch a lot of his arguments in non-revolutionary terms, that he was seeking to restore the original understanding of things, that the Constitution was not, for example, a pro-slavery document, things like that. Some of those were just sort of political, rhetorical tactics to sort of make things sound less radical and more reasonable than they might otherwise have appeared. Now, beyond that, I don't know. I mean, I think you can find plenty of rhetoric from the Revolutionary period that all they were really trying to do was restore their rights as Englishmen, right? That's all they wanted. Now, I'm granted some people didn't say that, right? And I'm sure you could find other Reconstruction era people who took a more radical view and sort of were proud to take that view. So I think that he probably, it's hard to get inside his head on that one. I mean, I think that he certainly at times made statements that were, as was pointed out by John, quite extraordinary, that certainly were not of a kind of moderate Burkean disposition, right? But what he ultimately thought about that as opposed to what his political posture was, I mean, I'm not sure. Now, on the Bill of Rights point, I'm pretty convinced that Bingham was didn't know what he meant by the Bill of Rights, okay, based on the 1871 speech as well as the reference to the amendments in the 39th Congress. Now, did others understand him to mean that? That's harder to say. I mean, I think because there were I'm working on a project now, a different project, where basically there were lots of different, as you say, definitions of the Bill of Rights in this time period. So it was not so clear. It's not so clear to me that that would be the understanding in general. But his view of that, I think, to me, I feel pretty clear that he knew what he was talking about. Okay, now on the sort of point about methods, well, I suppose abolitionist legal thought, and I mean, of course, Randy could, say more about this really than I can, is that they were forced into this posture where they were trying to argue that slavery was unconstitutional, even though the Constitution had pretty clearly thrown protections around it. So that, to some extent, forced them into a certain argumentative stance that was more unorthodox. Granted, they could have just said, hey, we'd like to have an amendment, and left it at that, but they didn't do that. They were trying to argue internally, at a minimum, to explain why slavery was inconsistent with other constitutional provisions, but then many went further to say, in fact, it was unconstitutional. Now, Bingham had a number of, creative arguments in this respect, right? especially, I mean, my favorite is the one about the fact that, well, the original 13 can have slavery, but the ones admitted afterwards only can if Congress permits them to, which certainly was interesting, let's put it that way. So I do think that should have an effect on the broader jurisprudential view that you think was being taken at the time of Reconstruction. So I agree that there is a change in method brought on by the fight against slavery and the need to appeal to natural law or other unconventional authorities in order to take it out of the text.
Okay, I just have a couple of points in moving from the general to the specific. I think it is a historical mistake to describe any of the Republicans in the 39th Congress as abolitionists. I think that the closest is probably Charles Sumner, and one of the members of the Joint Committee, George Boutwell, is referred to in a newspaper, one of my favorite newspaper accounts. Yeah, that makes me a nerd. Favorite newspaper account from 1868 is as Sumner without the idiocy. But they do, however, in court, particularly with respect to some of their this idea of Article 4 not being an anti-discrimination provision, take on a particularly out of the mainstream position which might have been associated with abolitionists, but I think it's important to recognize that I don't think any of them were really abolitionists. The question of abolitionists defined as they thought before the Civil War that Congress had the authority to outlaw slavery in the states where it existed, that sort of, or that they should take, well, we could talk about that. Okay, later. That on the question of whether it was revolutionary, I think here Michael S. Benedict's work is terrific about everything, but one book about the Reconstruction era, if you want to, is A Compromise of Principle. If you want to read one book about the politics of Reconstruction, every time I have a thought that's halfway decent, it's already in that book. But his point is that even though it was moderates who controlled moderate Republicans who controlled Congress, the moderates' vision of what Congress could do, at least during the Reconstruction era, would have been considered very extreme prior to 1861. So that's the first point. So on the point of the Bill of Rights, I think one of the things that's interesting is that in the 1870s, the Bill of Rights, that is the first 8 amendments, which it is always referred to rather than the 9th Amendment, is advanced as a limiting principle on the Privileges and Immunities Clause by Democrats. That Republicans are arguing for Bill of Rights plus. It's the Democrats who are arguing that the Privileges or Immunities Clause applies only to the first 8 amendments to the Constitution. So I think there's actually seems to be a consensus about that. That consensus is not inconsistent with Slaughterhouse itself, but it's later in Cruikshank and then Maxwell versus Dowd that consensus is rejected. On the issue of citizenship raised by David, I don't think it's fair to describe Tawney as a crazy outlier with respect to citizenship, because he, after all, has, although I don't think Dred Scott Holt, there's actually 5 votes for his position. There are, I think, 4 votes for his position. It is the Southern position, but I think it's also important to understand that the Northern position, that McLean is who says all free African Americans are citizens, is the extreme anti-slavery position, or the least racist position that was there at the time. That is, if you were going to talk about mainstream, you can't get any more mainstream than Benjamin Robbins Curtis, who is about as center right as you can get on issues. And his position is that it's the states who decide who is a citizen of the United States. That United States citizenship derives from state citizenship. So they do have to overrule. So they're rejecting all of those positions in favor of McLean's position, and they don't come to that view until sometime in the mid-1860s as part of the Republican campaign to say, and by the way, Lincoln, in the Lincoln-Douglas debates, doesn't take the position that free blacks are citizens of the United States automatically. He says it's a matter of state law. So Republicans generally don't come to that position until the mid-1860s as part of their campaign to delegitimize Dred Scott.
Okay. In our next group, we have Larry Solom, Gregory Maggs, and Randy Barnett.
It's a pleasure to be in another program on this book. And the last time I asked you, I sort of tried to push you into speculating, sort of beyond the evidence. I won't do that again. So if you're right in Bingham and sort of getting deep into Bingham answers surprisingly few of our questions, right? Then I have the following follow-up question. Do you have any sense as to who else we might look to, right? Because you sort of now have a deep familiarity with Bingham and who he was dealing with, right? So sort of if you wanted to write the biography of the figure who would yield the most information, and we now know it's clearly not Bingham, who else might it be?
And Gregory Maggs.
I really like this book. Learning history by reading biographies is just great. Who would have thought that we'd be reading about General Custer and Japan, military commissions? I find it fascinating. My question has to do with the idea or the question of whether the participants whose voices were recorded, including Bingham but not limited to him, thought that their views would later influence courts as opposed to just influencing other people to vote for the amendments. In other words, were they cooking the legislative history? Was there any indication of that?
And Randy.
I think the book is great. The previous event Larry's talking about is when Gerard came and gave the entire book to my seminar, Recent Books on the Constitution. So I've read the whole book. The book is wonderful. You'll get a lot out of the rest of the book as well. Not so much on the meaning of the 14th Amendment, unfortunately, but about Bingham himself. I'm going to refrain from, I'm going to resist the temptation to talk about abolitionist constitutionalism because I have some reactions to some of the comments that were made, but stick with my original question, which actually is similar to David's, about the use of the term Bill of Rights. And this really is for both Gerard and Earl, and I'm encouraged that Gerard's actually working on this now. So Pauline Meyer is now working on a project on how the term Bill of Rights came to be popularized to refer to the first 10 amendments. And she got this idea from Akhil Amar's reference to the fact that that the first 10 amendments were normally not referred to as the Bill of Rights. But she's trying to figure out when did that start and how did it start. And she asked me in the course of doing this whether, what the abolitionists said when they were talking about stuff. What do they call it? And I had never thought about looking at that. So I went back to all the 13 folks that I had surveyed, and it turns out not one of them had referred to the first 10 amendments as the Bill of Rights. They did. I saw a couple references to the Bill of Rights, but it was to the Virginia Bill of Rights or to other state bills of rights. But when they talked about the amendments, they called them the amendments. So, it wasn't standard use. At least, if whatever they were writing, it didn't come up. It didn't happen to come up. So I went back and I thought, well, what about Madison's Bill of Rights speech, his famous Bill of Rights speech? I mean, obviously, he's talking about the Bill of Rights, right? So, and I've always called it the Bill of Rights speech. But then someone's going to, I'm using the big data here to try to get the actual word. I'm going to give you the actual wording from this speech. So Madison says in his amendment speech, the first of these amendments relates to what may be called a Bill of Rights. And he says, I will own that I never considered this provision so essential to the federal Constitution as to make it improper to ratify it until such an amendment was added at the same time, blah, 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 blah. You probably know the rest of how this goes. Now, I always naively assumed it was the first part of what he was proposing, not the First Amendment that he was proposing, but that's what he literally says. It's the first proposal, this amendment. So what did that First Amendment say? That could be called the Bill of Rights. Let me just scroll up here. The First Amendment says, the first proposal amendment says, that there be prefixed to the Constitution a declaration that all powers originally vested in and consequently derived from the people, that government is instituted and ought to be exercised for the benefit of the people, which consists in the enjoyment of life and liberty and the right of acquiring and using property, and of generally pursuing and obtaining happiness and safety, that the people have an indubitable, unalienable, and indefeasible right to reform or change their government whenever it be found adverse or inadequate to the purpose of this institution. That's it. And that doesn't get into the Constitution.
Isn't that just called Article 1?
What's that?
Isn't that just called Article 1?
It says first, No, under, in,
Because he presents 12 or
yeah, secondly,
12 parts.
well, this
His
is,
amendment has 12 parts.
I'm just reading, I mean, it's not separately denominated as an Article 1. It says first that there, maybe it says later where it says the amendments which have occurred to me proper are these, first. And then I read what follows that. And then he goes, second, that in Article 1, Section 2, Clause 3, the following words be struck out to it. So this was a prefix that was supposed to be added to the Constitution in the beginning, and which we know was not added to the Constitution.
Was there later reference? I was trying to recall if maybe toward the end of the speech he summed up and referred to Declaration of Rights again or something.
There may be, but I'm just at this point I didn't have a chance to go through the whole thing again. Just to inform. I just wanted to bring everyone up to speed on this particular thing, which suggests that when he's referring to the Bill of Rights in this speech, he's talking about his first proposal, which doesn't make it into the amendments, and which is echoed in state constitutions. It's very common language in state bills of rights, including the Virginia Declaration of Rights. And I think it actually is echoed in Corfield, frankly. I mean, I think Corfield, in the core of Bushrod Washington's analysis of what privileged immunities is very comparable, similar language to what this is. So here's my question. What have you guys, how would you answer Pauline Meyer's question about when did the Bill of Rights when did we start calling the first 10 amendments the Bill of Rights? Amar attributes it to the Republicans in Congress. Meyer seemed, I don't know what I just talked to her when she was starting. I don't know what her conclusions are. She's sort of thinking it came out during the during the Reconstruction Congress. What do you think about when this terminology actually came to be the terminology?
Well, I'm glad you asked because I'm working on an article about this. So that tees it up very well. Actually, after I presented the book at Randy's to Randy's class, and he mentioned that Pauline was working on this, we emailed quite a bit because she was interested in Bingham, and we wanted to talk about that. And sort of the thought that we had in exchanging these emails, well, it must have happened around World War II. That's sort of the time when the Bill of Rights really becomes the Bill of Rights in capital letters. And so what I want to say in this article I'm working on is that it's because Franklin Roosevelt invoked the Bill of Rights frequently and in detail in widely publicized speeches, and did so in a way that then was both responsive to but also influenced the legal culture. And that one piece of evidence for that is that you see a significant spike in the number of references to the Bill of Rights in Supreme Court opinions. If you look at the 1930s versus 1940s, it's kind of a big difference, and the level of detail in those references is also significantly different, and that there are some interesting relationships between FDR's use of the term and the court's use of the term, especially beginning in Barnett, right? That Barnett is kind of the other Barnett. Right. And so my answer would be it basically starts with the New Deal, and then sort of the New Deal, World War II, I mean, for different reasons, but that's sort of where it comes from. And there are certain reasons why FDR latches onto the Bill of Rights as a way of warding off criticism of the New Deal, as well as sort of distinguishing our Constitution from Hitler's. But that's getting kind of far afield from from this, but that's, yeah.
Can I follow up before Earl answers? Well, if there's any semblance of insight available to Madison's referring to this proposal as the Bill of Rights, which would not make it into the Constitution, does that make what Bingham says about the Bill of Rights, his reference to the Bill of Rights, less crazy than his critics like Fairman have accused him of being? That is, what he's saying is a lot more, perhaps possibly more standard usage than what we think of. It's only reading our usage back that makes him sound crazier.
It could be. I didn't know about Madison's usage, so that's an interesting thought.
I would jump and say that Bingham refers to the Bill of Rights in the amendments. He frequently links it to the amendments, so it's not. He doesn't seem that crazy.
So my wife will tell you you're about to hear one in a row, which is I don't know the answer to that question. But there is an important element to that, which is that it's nonetheless makes sense when they're talking about privileges or immunities of citizenship to refer, whether they're talking about it, they begin to talk about it as the Bill of Rights, but also that the things that were included in the Bill of Rights would be included would be fundamental, as well as other things that would be fundamental. So that's the only comment that I have about that at all.
Just to answer Larry and Greg's question, okay, so for Larry, of course, this book is the book you should read if you want to know the most about the 14th Amendment, right? But I mean, to say what other person that I came across seemed really interesting for a biography, the answer would probably be Bingham's mentor, Joshua Giddings, right, who was also in Congress from Ohio and was the this disciple or apprentice, if you will, of John Quincy Adams in the House. So was considered a leading abolitionist member of the House, and struck me as kind of quite an interesting guy. They exchanged a lot of correspondence before Giddings died during the Civil War, and kind of struck me that somebody ought to maybe take a closer look at what he was up to in the 1840s and 1850s, kind of leading up in this sort of line of thought. Okay, on the question of legislative history, no, there's no evidence that they were doing that with any thought to what courts would do with it. I mean, the only thing we do know is Bingham did take a long trip with Justice Miller in 1871 to California and talked to him a whole lot. Whether effectively or not is kind of hard to say, since we don't know what Bingham thought about Slaughterhouse. But that I guess was the more the way of influencing justices back then was to just go and chat with them about what's going on or your constitutional attitudes, rather than trying to cook the legislative history.
With respect to Larry and Greg's question, with respect to Larry's question, I don't think there is a biography. You know, my personal favorite of somebody, a biographer, I have some people I'd like to see biographies about, but I don't, because what they are doing is, if you read through the legislative history of this and some other things, and the other parts in Section 2 in particular, is that they are making references to accepted legal texts as things like, for example, things like Vattel on citizenship, Story's commentaries on the Constitution, a variety of cases, including Corfield. And they are this gets to both questions, right? They're very definitely thinking about that. Further, if you look at the way that, again, particularly Sections 1 and Sections 2 are drafted, the whole drafting process, it's very clear that they are trying to be as careful as they can with the legal, with language and thinking about the legal implications of that language. Now, that's not inconsistent with making sort of grandiose general claims when you are trying to sell the language. So that in that sense, maybe if you're talking about grandiose general claims about, oh, this is just going to make the world, wonderful, like Obamacare, those things are, they're political puffery, but that's not inconsistent with the idea that they were taking great care with the language that they talked about. And indeed, again, if you look at the discussions, one of the things that's remarkable about the discussions at some times when they're getting down to nuts and bolts and talking about particular language is about how careful they are with language about citizenship. And if I was language about the amendments, and if I was going to refer you to something about citizenship, I would look at the discussions of citizenship in connection with the Civil Rights Act of 1866, when they're trying to figure out which Native Americans to make citizens and which not. And then at the end, they go back and said, we don't like that. When Trumbull was asked about it in the 14th Amendment, he said, we didn't like that language. We finally decided that this language was the best we could do. I hope that was answerable to your question.
Okay, and our final, we so far just had two people I was going to put myself in, but Mike Rappaport and Mike McConnell. And since I jumped in, I'll just see if there's time. So there's about 7 minutes left. So if Mike and then Mike could.
I should take myself off. I was going to jump in and talk about Section 2 of the 14th Amendment, but it's really not relevant. So why don't you take my place, Brian?
Well, I'll go to Mike McConnell next.
So this doesn't directly come out of the reading, but having the two of you up there to take advantage of, I can't resist asking this question, which is what the legal force of the first sentence was thought to be. And I'm thinking now of the fact that the next sentence only limits the states and seems to have no application to the federal government, and yet it has been argued recently that Bowling against Sharp and so forth, and applications of equal protection to the federal government is justified by the first sentence on the ground that everything in the second sentence is effectively a right of something that would be expected to pertain to citizens, and thus I guess the logical implication of this is that they could have just stopped at the first sentence and not bothered with the rest. But what is your sense of the substantive payout from the first sentence?
I don't have a great answer to that because, first of all, since Bingham didn't write the first sentence, I naturally sort of shifted focus to the portion that he did write. So that's part of the answer. And I don't know that, and nor did he express any view with respect to reverse incorporation that I could find. So I'm going to have to plead that the record does not give me the ability to answer that question.
Let me let Randy jump in, actually, since he was the second in this group, as it turned out. Go ahead.
I volunteered again, so I wanted to say something about abolition and constitutionalism that I didn't say before. One thing, Gerard, and that is that Bingham's view that slavery was only constitutional in the original 13 states was not aberrational at all. It was standard anti-slavery constitutional view. They thought that slavery was was prohibited in the Northwest Territories and any states that were formed therefrom. And in fact, that the runaway servant law, slave law, talked about people who had fled from a state into another state, I think, and not into the territory. I can't remember exactly, but this was just sort of standard approach that they took. Earl caught me making a face when he was talking about who was an abolitionist and who was not an abolitionist. I didn't mean to make a big face. I'm sorry that you caught me at that. I mean, but there is a kind of a weird terminological problem with the way historians insist on the way we talk about these folks, because first of all, there was a definite schism among them, and you had the bulk of them who became the core of the Republican Party, who argued that slavery was constitutional in the original 13 states, but it could be abolished in the territories and the District of Columbia, and it was unconstitutional, and the Fugitive Slave Acts were both unconstitutional for a variety of reasons. And so they had a very robust platform, but they conceded it was constitutional in the original 13 states. Then there was a subset, led by Spooner and a few others, that argued that it was unconstitutional everywhere, but that was not really the majority of that group. But when the historians tell us how we're supposed to use the word abolitionist, and we're supposed to say these anti-slavery Republicans, or who became the Republicans, are not abolitionists, and they were not really abolitionists, what's their criteria? Well, the actual people who it's okay to call abolitionists, which are the Garrisonians. I mean, if anybody's abolitionist, it's them. They thought the Constitution was a covenant with death and an agreement with hell because it sanctioned slavery all the way down. So clearly, it's okay. The criteria. Right. So right, exactly. So the criteria of who's an abolitionist can't turn on what you think the Constitution necessarily says about it. It has to turn, because they were the worst. They were the most extreme pro-slavery readings of the Constitution. So it's got to turn on other things. And it's true that a lot of people who were anti-slavery denied they were abolitionists, but that's partly because it had a bad rap, and they were running for office, so they were trying to build a political party, and they didn't want to be associated with those folks. So I just think terminologically there's a lot of confusion amongst historians, conceptual confusion amongst historians about what the terminology ought to be. And I think the better terminology, which is not original to me, and that is to distinguish between the radical abolitionists, who we'll just call the Garrisonians, who were they were disunionists, they believed in the abolition of the Union, and they were against political action. Then there were the political abolitionists, who decided to try to work for the abolition of slavery by political means, by forming political parties, First Liberty Party, Free Soil Party, Republican Party. And as a subset of them, there were the constitutional abolitionists, who believed that the Constitution, and Spooner, by the way, is kind of not a political abolitionist, but he is a constitutional one, who believes that the Constitution is fundamentally anti-slavery, whether or not it goes as far as Spooner said, and could be used to basically put slavery on the road to extinction. That platform gets included in the Republican Party platform via the Liberty Party and the Free Soil Party, and it's what drives the South out of the Union, because even though the promise is made, we're not going to touch slavery in the 13 states, they see the rest of this platform and they say that we don't like that. That's going to put us on the road to extinction, and we're out of here. So that's it. I'm sorry.
Okay, great. And there's a couple minutes left to hear the last word from either Gerard and/or Earl.
Well, with respect to, I think Gerard's point is important about the first sentence, whether you would have needed the second sentence if there weren't if you had the first sentence already, the first sentence being added at the end. I think that citizenship is a political and symbolic status as well as a legal status, but it's mostly legal. But that you might still have wanted to have the privileges or immunities clause just to make sure that about what states could do or not. But again, it was out at the end. With respect to bowling, I think the due process clause was generally understood to prohibit class legislation, but then we have this long discussion about what we mean by class legislation, and that's how you would get to bowling if you believed that segregated schools were class legislation, and I know we disagree about that. So that's as much as I can say about that.
Any further responses? All right. Well, thank you very much.
Thanks. Thank you. Yeah.